This webinar aims to help clear any confusion surrounding the impacts of Brexit on how you manage your tenancies. If you are a landlord, you may be worried about renting to foreign tenants once the UK has left the EU. We want to help you be confident that you're doing everything in line with legal requirements. If you still have questions after watching this, you can contact Landlord Advice on 028 90 245 640. The UK plans to leave the EU, and as a result, there is lots of confusion out there about the impact of that on many areas of life and business. Luckily, there will be little change to the housing rights of European nationals who reside in the UK after Brexit, so there's no need for you to change your approach to renting and managing your tenancies. In fact, you could be breaking the law if you start to treat Europeans differently to British or Irish people. We will look into that a bit more later on. One of the more confusing areas for landlords in Northern Ireland is whether you need to adhere to right to rent legislation. You don't. Right to rent applies in England only, where it makes it a criminal offence to rent a property to someone who doesn't have permission to live in the UK. In March 2019, the High Court ruled that the scheme would have to be significantly changed before it could be rolled out in Northern Ireland. You can read more about this judgment at housingrights.org.uk. Because this doesn't apply to landlords in Northern Ireland, you can't get in trouble for renting a property to someone who is here illegally. You can't ask potential tenants who are EU nationals to provide evidence of their nationality or of their right to live in the UK unless you also ask this of every other potential tenant. EU nationals who already reside in the UK can still apply for benefits and will have much the same rights to access benefits as they did before Brexit. You may hear people referring to new categories of immigration control used for European nationals. These are settled status and pre-settled status. If a European national has settled status, it's because they have lived in the UK for at least 5 years. They will be treated in exactly the same way as a British or Irish national who applies for benefits. If a European national has pre-settled status, they have lived in the UK for less than 5 years. They will now have to show that they are eligible for benefits. The same process will be used after Brexit as is currently used when deciding if a European national can claim benefits. A person will usually be eligible if they are working or if they have worked in the past but are temporarily unable to do so. A person can also be eligible if they are the family member of a European national who is working or is temporarily unable to work. If you have a European tenant who needs help to pay rent, encourage them to apply for benefits and to get advice from somewhere like Housing Rights. As a result of Brexit happening, it's important you do not treat EU citizens less favourably than you treat other persons, such as local people. Doing this would likely amount to unlawful racial discrimination under the Race Relations Northern Ireland Order in 1997. These rules won't be changed by Brexit. Under the Race Relations Order, it is unlawful for a landlord or agent to discriminate on racial grounds against a person who has rented or who wants to rent a property. The landlord could be taken to court and could be ordered to pay damages to the person who is discriminated against. This can include covering financial loss as well as damages for injury to feelings. The Equality Commission can also take legal action against someone who has advertised a property and indicated that they intend to discriminate against applicants on racial grounds, or pressured an agent to discriminate against potential tenants on racial grounds. We can look a bit more into what would constitute direct or indirect discrimination on racial grounds. Direct discrimination occurs where a landlord or agent treats a person less favourably than others because of that person's actual or perceived race, colour, nationality or ethnic or national origins, or because of a person's relationship with another person who has those characteristics. For example, showing a vacant property to a British person but refusing to show this property to a Spanish person because of their nationality, or deciding to evict 2 European tenants from a house share and allowing their Irish flatmates to remain when there is no reason for this differing treatment, or advertising a property as not being available to foreigners. You cannot justify direct discrimination. You cannot defend your actions by, for example, saying that you were worried about renting to European tenants because of intimidating graffiti nearby. Indirect discrimination occurs where a landlord or agent applies a condition, criterion, or practice to all persons, but it has the effect of causing a greater disadvantage for certain racial groups. Examples of indirect race discrimination include asking all applicants to provide a guarantor who is a homeowner in Northern Ireland, or insisting that applicants are able to communicate in fluent English. Even though these examples are applied to everybody, it is going to be harder for people who are foreign nationals to satisfy these conditions. A policy or requirement that indirectly discriminates against someone on racial grounds will be unlawful, unless the landlord has a satisfactory and non-discriminatory reason for this requirement. The landlord or agent will need to be able to justify the policy if they are challenged at court. Racial harassment occurs where a landlord or agent subjects a person to unwanted comments or other behaviour on racial grounds that are offensive, humiliating, intimidating, hostile, or degrading. If, for example, a member of staff in a letting agency is overheard making an offensive comment about someone's ethnic or national origin, the agency will be held liable in law for this action unless the agent can show that reasonable steps were taken to prevent such actions occurring. The Equality Commission website contains advice for employers on adhering to the Race Relations Order, and this includes a sample equality policy for service providers. It is also important to remember that harassment of tenants is a criminal offence under the Private Tenancies Northern Ireland Order 2006. You may be worried about European tenants moving away from the UK after Brexit. If your tenants decide to do this, they are still required to give you notice to quit, and you can still use their deposit to cover reasonable losses, such as unpaid rent or damage to the property. There is an EU cross-border small claims procedure which landlords could have used to sue tenants who owed rent and who had moved to another EU country, but it's unlikely that this will still be available to people resident in the UK after Brexit. Concerns the European tenant might leave the UK after Brexit doesn't give you a legitimate reason to charge a higher rent. Landlords are free to set whatever rent they want for a property, but it is likely to be an act of unlawful racial discrimination to charge a higher rent to a European tenant than you would charge to a British or Irish tenant just because of their nationality. There was a sharp rise in hostility towards European people after the results of the 2016 referendum were announced. Some people are concerned that this type of hostility could reappear when the UK leaves the European Union. If your tenants have been attacked or harassed because of where they are from, this is probably a hate crime, and you should encourage them to report such attacks to the PSNI. Your tenants can get help to deal with hate crime from the Migrant Centre and from victim support. If you are a registered landlord and have any queries about managing your tenancies, give us a call. Landlord Advice helpline is available Monday to Friday from 9:30 to 2:30 and can help you with any queries you have about your legal requirements. Call us on 028 90 245 640 or email at advice@landlordadviceni.org. To recap what we've gone through in this webinar, after the UK leaves the EU, there's no need to change your approach to renting. Right to rent doesn't apply in Northern Ireland. EU nationals will have much the same access to benefits. You can't start treating EU nationals less favourably. You can't charge a higher rent to EU nationals. EU nationals will still have to give notice to quit. You should get familiar with the Race Relations Order and look out for tenants who may be victims of hate crime. And if you're unsure about anything, seek advice. The information presented here is correct as of December 2019. However, there is still uncertainty around areas such as immigration status and access to benefits. Follow us on Twitter and Facebook or check back regularly to housingadviceni.org to make sure you are up to date on how to manage your tenancies after the UK leaves the EU.